Employment arbitration in Austria. For the time being, employment arbitration is not very widely utilized by employers and employees in Austria. The reason for that is that while disputes involving employees are considered arbitrable in principle, the Austrian Code of Civil Procedure stipulates numerous preconditions for the validity of arbitration agreements where an employee is party to such an agreement. Accordingly, arbitration agreements between employers and employees can be validly entered into only after the employee has been given written advice on the difference between arbitrations and proceedings before the ordinary courts. The necessary content of such advice to be handed over to the employee is not clearly regulated. Thus, from our experience, the requirement to provide such written advice often remains an obstacle in reaching a valid arbitration agreement when an employee is involved. Furthermore, such an arbitration agreement must be contained in a separate document. Due to the requirement that such arbitration agreement in most cases can be reached only after the dispute has arisen, the employees often cannot be convinced by the employer of the necessity to confer a matter to arbitration rather than to the ordinary courts. Those Austrian courts, based on their understanding that labor laws are protecting the weaker party of an employment agreement, and for the avoidance of doubt, that is the employee, are deciding their cases rather employee-friendly. That often adds to the reluctance of employees to agree on arbitration. Additionally, in many cases, employees are supported by their representatives, that is, works councils, chambers of labor, trade union, in court cases before the ordinary courts. Thus, employees in Austria often do not have to pay for the court dues, if any. They do not have to pay for the costs of their own legal representation either. And even if losing their entire case, they do not have to bear the costs of the opponent. Accordingly, the access to justice is considered by the employees to be widely safeguarded by these measures. Accordingly, due to the fact that these comparable benefits are not provided in case of arbitration, from an employer's perspective, it is often difficult to convince an employee of the advantages of arbitration. Additionally, the arbitration agreement must specify the seat of the arbitral tribunal. The seat must be at the employee's domicile, residence, or place of employment at the time of the conclusion of the arbitral agreement or at the time the claim becomes pending. Otherwise, the employer will be prevented from invoking it. Again, from an employer's perspective, these prerequisites do narrow the leeway for an employer in deciding how and when to arbitrate an employment matter. Furthermore, certain collective labor and social law matters, that is, matters concerning social security issues or disputes concerning the collective representation of employees in an enterprise, are entirely precluded from arbitration. As mentioned before, most labor law matters can validly be made the subject of an arbitration agreement only after the dispute has arisen. However, there is an important exception to that rule. Disputes and future disputes arising from employment contracts of managing directors of limited liability companies and stock corporations are arbitrable. Invalid arbitration agreements, however, lack legal effect, with consequences for the jurisdiction of the arbitral tribunal and the proceedings based on such an invalid agreement. However, if a party has entered an appearance in a case without raising an objection alleging a defect with its first submission on the matter, it is generally barred from raising these objections at a later stage. In line with the competence principle governing Austrian arbitration law, the arbitral tribunal will, in the first place, decide whether a matter is capable of being submitted to arbitration. Under the Austrian Code of Civil Procedure, recourse to the state courts against an arbitral award is possible, if the matter in dispute is not arbitrable under Austrian law. Thus, the Austrian Supreme Court has the ultimate say as to the arbitrability of a matter in dispute. Overall, the above-mentioned requirements involved when arbitrating most employment matters often lack legal certainty for the employer. Accordingly, Austrian employers often prefer to start legal proceedings before the ordinary courts and, with the support of their legal assistants, negotiate a settlement agreement rather than awaiting a final decision by these courts. All the best.